This is our IEP workshop part one. It is designed to help everybody understand special education rights and recognize red flags when you're in meetings with students' school. It's being presented by Elizabeth, who just introduced herself, and me, William Hrabe. We'll give you a little background on ourselves in a second, but we are both with Matt Cohen and Associates, special education, disability rights, and human services law firm. And I would say the bulk of our work is focused on students with disabilities, and specifically students who are in the public school system with disabilities. But we also do work with college age students, ADA accommodations, things like that. And a quick note as we're getting started, I'm going to talk a lot about the law and your legal rights as an interested party of a student with a disabilities education. Just need to clarify, of course, that this is general information about the law. And while we hope it will be helpful for you and the students with disabilities in your lives, it's not intended to convey legal advice. If you would like specific legal advice about an individual student or situation, we would recommend you follow up with the firm so we could talk to you more in depth about your specific situation. So we already touched on this, but if people are joining late, feel free to add in the Q&A section what brings you here today and what you're interested in learning. A quick overview of what we're planning to go through. So first, like I said, we'll give a little background on ourselves. We will then give you a crash course on Introduction to Special Education Law. And like I said, the slides, especially in regards to special ed law, are very overwhelming. I'm going to try to touch on all the important things, but it's all there so you can go back and review when you have a chance. And then we're going to get into an IEP walkthrough, which is going to be the bulk of the presentation today. We're going to take you section through section of the IEP. I'll talk about the relevant laws that control those sections of the IEP. And then Elizabeth will go into the application of how those are borne out or represented in the IEP. She's going to provide you with an IEP overview tool that she has found very helpful in her advocacy work. And then we'll give some tips and feedback about what goes into a good IEP, how do you write a good IEP. And finally, we'll conclude with suggestions for what to do when you disagree with the IEP team or the IEP. We're not going to get into that too much today. That will be more the focus of part two of this presentation, which is advanced advocacy strategies, but at least an introduction to kind of what your options are when you have a disagreement with the IEP team.
All right, so I am Elizabeth Hooper. I've been teaching special education for a very long time. I first started off in general ed. I've taught in pretty much every capacity for special ed, pretty much every age. So I feel like I have a pretty good sense of what programming should look like, and what it maybe shouldn't look like across a variety of settings. I've been able to do private advocacy for about 12 years now. The last 6 with Matt. And I just want to share as someone who worked in schools for a long time and really promoted a collaborative model of let's share resources and expertise to make sure we're doing the best by our students. Joining Matt's firm has been really wonderful because it really is a team approach, right? Where we're very much pulling together the expertise of our varied staff to efficiently and effectively get the job done. And then I also have the privilege of continuing to get to teach. So I do private executive functioning coaching. I don't know if you could see that there's a board behind me with a variety of random letters. You get to enjoy my mnemonics as well. I figure if students have to stare at me, they might as well learn my mnemonics. And I'm a parent of 2, so I'm really getting to see a variety of, sitting at the table, being a parent. I've gotten a wealth of different perspectives.
Great, yeah. And like I said, my name is William Hrabe. I'm an attorney with Matt Cohen and Associates. I did my undergraduate at University of Illinois in Urbana-Champaign, and while I was there, I majored in political science and disability studies, which was a cool opportunity where I actually created my own major. And you might be putting 2 and 2 together. And yes, I did it with the intent of becoming a disability rights attorney, specifically special education. And before I joined Matt Cohen Associates, I worked at Equip for Equality in the special education clinic, where I had a fellowship project that focused on Chicago public schools, the public inquiry, and systemic issues. And while at MCA, I've been really fortunate to be able to continue a lot of that work. And one of the things I'm really interested in this area of law is sort of the need for systemic education, reform, parents having the information and the tools to be able to help their students, because it's an area of law that parents are sort of thrown into and forced to grapple with and often don't know what their rights are. So hopefully, we can help some of you out today with learning a bit more about that. So, crash course on special education laws. The most important law, and the law we're going to be focusing on today, is the Individuals with Disabilities Education Improvement Act of 2004, or IDEA, also referred to sometimes as IDEIA. The 2004 version is the newer version of what was previously existing as the Individuals with Disabilities Education Act. So the two are somewhat interchangeable. We still call it IDEA because I think everyone just loves the acronym. That is the federal special education law that controls IEPs. Two other laws or areas of law that we'll touch on but not talk as much about is Section 504 of the Rehabilitation Act, or Section 504. That's the federal anti-discrimination law that applies to schools, and that's the law under which 504 plans are created. And I saw a few people respond that they either have had a 504 plan or been frustrated with a 504 plan. So we'll talk a little bit about that and the difference between a 504 and an IEP. And then we'll note in a few areas Illinois state special education laws as a general note, and the attorneys here will probably know this for other areas of law. States must at least follow the federal law, but in some cases they may have laws requiring a higher standard or giving students more rights. So in a few areas we'll note an Illinois special education law that applies. So I said we're going to focus on IDEA, overview of what are my rights? What are my students' rights under IDEA? Well, there's 4 sections of IDEA. We're going to be focusing mostly today on Part B, which is the assistance for education of all children with disabilities. Part A, general provisions, that's mostly introduction, definitions, background on the law. Part C, infants and toddlers with disabilities. You might be familiar with this area. This applies to early intervention, so services for children who are between the ages of 0 and 2 or through 2. And then Part D, we're not going to talk about that. So I guess don't worry about it for now. Another important note, though, when we're talking about special education rights, all of your rights aren't going to be found in the IDEA. And the reason for that is because when Congress sits down to write a law, they outline what they think the law should be, but they don't always or aren't always able to think through what are all the ways that this could apply or how could it be interpreted. And so there are 2 other areas that we'll look at today for guidance on what does the IDEA, what rights does it give me? We'll look at the Department of Education regulations, and those are regulations that are put out by administrative agencies who are in charge of explaining how these laws should be interpreted and applied. So they don't necessarily have the force of law, but when you're trying to determine what does this law mean or how does it apply to my situation, a good place to look is the Code of Federal Regulations, and we'll specifically be looking at 34 CFR Section 300, which is the Department of Education regulations for IDEA. And then finally, we'll look a little bit at some case law applying IDEA. So when there's a disagreement about what the law says, or people aren't sure of what the Department of Education has put out interpreting the law, that means courts decide. So someone will file a suit and go to court, and a court will basically tell us what their interpretation of the law is.
And Will, I'm going to interject for just 1 second here. Yes, this recording will be shared, so please don't feel like you need to feverishly write notes. And we'll be posting it on our website. And while you're there, there's a bunch of other topics that we're just touching on that we go into more depth, like for instance, early intervention, early childhood, a whole lot of stuff that we have many in-depth topics on, but please don't feel the need to write all this down. Thank you.
Yes, thank you. Especially as I try to talk quickly to get through all of this background on the law. So, we start with IDEA, we look at the regulations, we look at case law. So let's start with IDEA. What does it say? Well, the purpose of IDEA is to ensure that all children with disabilities have available to them a free, appropriate public education. You've probably heard that term before if you've been at all in or around special ed law. It's often abbreviated as FAPE. And IDEA basically says your student has a right to FAPE to prepare them for further education, employment, and independent living. IDEA also says that it's to ensure the rights of children with disabilities and parents of such children are protected. And that's a really important aspect of the IDEA. We're not just talking about the rights of students with disabilities, we're also talking about the rights of the parent and how they can be used to protect you as you are involved in the education of your student. Also, in a different section of IDEA in the monitoring priorities, it tells us that the provision of free appropriate public education must be in the least restrictive environment. So put those together, what do we have? Your child is entitled to a FAPE in the least restrictive environment. Okay, great. So what does that mean?
Mhm.
Well, we can look in the IDEA for their definition of FAPE. I've put it up here. I'm going to warn you. It's not very helpful. It won't tell you actually what your child is entitled to, really, other than that they should be provided an education at public expense. So what does that mean for your student? All right, well, you're all smart people. Well, Will just told us, let's go look at the federal regulations and see what they tell us about FAPE. Unfortunately, the definition in the federal regulations is very similar to the IDEA definition. They do provide us some additional information, like that FAPE is for students who are between the ages of 3 and 21. I will note that they do allow some exceptions depending on state law in this area, but in Illinois, students are entitled to a public education from the age of 3 through 21, so until the day before their 22nd birthday. The federal regulations also give us some other FAPE requirements like residential placement, assistive technology, extended school year, lots of things that might be part of an appropriate education, but it still doesn't explain what the heck an appropriate education is. All right, so let's look at the case law. What have the courts said? Well, this has changed somewhat recently in 2017. For those who are in and around special ed, you're probably aware of this because it was a really big decision. But a quick look back to 1982, the Supreme Court first said that an IEP must be reasonably calculated to enable the child to receive an education benefit. And the problem with this decision in Board of Education of the Hendrick Hudson Central School District was that many courts took this to mean that they weren't required to maximize a student's performance, but only offer some educational benefit. So for a while, we saw a lot of courts basically saying, as long as a student makes minimal progress, that's good enough. Well, about 5 years ago, around came Andrew F., which is currently the landmark decision in special education law. And they rejected the view that FAPE only requires students to make more than de minimis progress or minimal progress. They said that when a student's fully integrated in the regular classroom, they should typically provide a level of instruction reasonably calculated to permit advancement through the curriculum, so to allow the student to keep up with the gen ed curriculum. And if a student isn't going to be educated in the general ed classroom, their program must be appropriately ambitious in light of the student's circumstances. And they concluded by saying every child should have the chance to meet challenging objectives. So we still don't know exactly what that means. We still have to kind of parse through those words, but we know that it's more than minimal and that it should be challenging for the student based on their individual situation, that it should be appropriately ambitious, not just minimal progress. Okay, so students with disabilities are entitled to FAPE in LRE. We just went through FAPE. I think an easy way to provide a summary of that, of what we just went through, is that education for students with disabilities must be designed to meet their needs to the same extent that the needs of non-disabled students are met. And what is the least restrictive environment? Well, this is a bit of a spoiler alert for the next slide, but students with disabilities must be educated with non-disabled peers to the maximum extent possible. Where does that come from? Well, for LRE, the federal regulations actually are more helpful than they were with the definition of FAPE. At 34 CFR section 300.114, they explain LRE requirements, which says that to the maximum extent appropriate, children with disabilities must be educated with children who are non-disabled. And And the second one is equally as important, if not in some cases more important. Special classes, separate schooling, or other removal of children with disabilities from the regular education environment occurs only if the nature or severity of the disability is such that education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. And so, after we finish today, I want you to go back and look at this slide because that's some really strong language. We're saying that it should only occur if there's basically no way that you can give them an education in a regular ed class with supplementary aids and services. So when we talk about FAPE in an LRE, that's what we're talking about. And next, and I'm going to hand it over to Beth in a minute, but we're going to walk through the IEP. So take that, 15 minutes that I gave you, sort of throwing all special ed law at you, and say, okay, well, how does this actually apply to the IEP? For those who aren't familiar, the IEP is the Individualized Education Program, and that's a document that outlines services a student will get in school to get FAPE in the LRE. So it basically says, how are we going to give the student FAPE in their LRE? And as we walk through, we're going to look at a variety of relevant sections in the IEP that are outlined here, starting with the student and meeting information at the top, present levels of performance, the goals that are in the IEP, accommodations and modifications, other special factors, supports for school personnel, transition services, and then finally, we'll talk about educational placement and the LRE grid.
Could you scooch down one more, sir? Do you have the sample? Great. So I'm starting with this because so the slide before showed a template, and that we're planning to email that template out as a Word document so people can fill this in as you'd like. I started using this document as a teacher to help keep clear what each student was getting and making sure as a case manager that the IEP was being implemented with fidelity. And again, I had an understanding of who the student was at my fingertips. And then it morphed over the years where I found, wow, this is so helpful for me. I should be sharing this with other people. So, the IEPs that I would, dogtail and annotate that general ed staff often didn't understand what they were looking at or didn't read. This I replaced with this. And I found that this was, coffee stained and rumpled and in subfolders. Again, obviously clarifying confidential information, but man, oh man, is it a really helpful tool. I see that a lot of schools these days use what's called an IEP at a glance. It's a lovely tool as well. It's a couple of pages, and I still find that you need some, it's not so intuitive, and there's something magical for a lot of school staff about one page, right? So, and then I've found that when I've moved from being a special ed teacher to an advocate, how powerful it was for families to have this information and have the skill set to be able to fill this out. This means that you know what information is included in the IEP and you know where information should be. One of the things I often hear from people is that, I tried to bring this concern at an IEP meeting or with the team, and you were just rebuffed by, well, this is not, this is not, I'm sorry, let's see the Q&A question. So just real quickly here, some of the questions about like, how do we address this? We'll touch a little bit on later, and we'll try to weave in through the conversation. And again, that second part two of this is kind of a spiraling presentation where we're going to go a little bit deeper into those advocacy strategies. So again, empowering families to be able to fill this out. Again, so you're at a fingertip, right at a glance, you know where things are at, as well as it's a very powerful document to keep track of important dates. You see up at the top, right? So things are coming up. Schools have 60 days to complete evaluation. So you want to be mindful of the 60 school days to complete evaluation, be mindful of that time. And it lends itself to tracking changes over time. So you will hear Will and I talk often about progress, meaningful progress, right? So this is one way that we can see. So for instance, if you look at the goals and you go, it's exactly the same goal as last year. And maybe the evaluation criteria is also the same. that can be a powerful indicator that maybe that program is not calibrated for meaningful progress and changes should be made. So again, I found this to be a very helpful tool to not only be very, so that you as an individual are well informed and organized, can so real quickly, oh, this is what's going on, as well as disseminate key information to other people. In fact, this was one of the things, like I said, about teachers and stuff. This was also part of when I put plans or packets together for aids. I'm gonna bring that up again later. Instructional aids. This was also front and center. Again, confidentiality was very clearly communicated, but what a helpful document I found this to be. Thanks, Will.
Yeah, and I think just kind of piggybacking off of that, I see a number of comments in the Q&A about, my student school doesn't understand, this type of disability or that type of disability, twice exceptional students, girls with autism, things like that. And unfortunately, the reality is that you have to be the strongest advocate for your student with a disability. You know them better than anybody, you know their strengths, you know their weaknesses. And it's just, I mean, it's unfortunate, but you can't rely on the school or the school district to identify all of their needs or to meet all of their concerns. Maybe even to get an individualized education program, which is the name, right? But we'll hear schools say, well, this is the IEP that we use for students with autism. And that's not the idea. And so I think this provides, and hopefully you all find that this template um, provides a really succinct way of identifying what does my child do well, what do they struggle with, how can we improve on that, and how can we make sure we're tracking that improvement to see progress towards those goals year over year. So now with that in mind, we're going to dive through all of the sections, section by section. And, kind of the way we formatted this is I'll provide an overview of what the relevant law is that, guides the reason that this section or this information is in the IEP. And then Elizabeth will talk about, how that's applied to the IEP, how that shows up, and identify things we like to see and some things we don't like to see when we're looking at that section of the IEP. So starting from the top, the very first section of the IEP is usually just student and meeting information, right? Background information. And that might seem like kind of just standard, oh, you fill out a date, you fill out a name, things like that. But there's actually a lot of important legal protections that go into some of the information in those sections. And a lot of that is found in IDEA Part B, as I referenced earlier, Section 1414, which lays out the procedures for evaluations, eligibility determinations, IEPs, and educational placements. So, for example, it tells us that the IEP team must hold at least one IEP meeting annually to review and revise the IEP. Now, that doesn't mean they're limited to one meeting a year. If the school or the parent decides that a meeting is needed sooner, either because the student isn't making appropriate progress, because the student needs some additional services, or maybe the student is making tremendous progress and they've already surpassed some of their goals, you can request a meeting sooner or more often than once a year. The school doesn't have to agree, but you are able to request it, and oftentimes it makes sense to do so instead of maybe waiting until the end of the school year when your IEP meeting would normally come up.
Hey, well, can you take a second to talk about when a family requests a meeting, what should they reasonably expect from a school to respond?
Well, what you should reasonably expect is to get some response. The school is required by law to provide a response to your request for a meeting or your request for an evaluation within 10 days. It doesn't mean they have to do it. If they agree, then they should schedule a time to meet, a date to meet. If they disagree, they should explain why they don't think it's necessary to convene a meeting or to, conduct updated evaluations. In terms of whether or not they'll actually agree to the meeting, it's hard to say. It depends on the student. It depends on when your most recent meeting was. It depends on if there are new concerns that have been identified. But we often advise parents to request meetings sooner than their annual meeting, and frequently schools are willing to meet. So I would say that's always, a good place to start if you have concerns and you want to talk with the team.
I'm sorry, also just too, sometimes new information, like you get a report, an outside report, that can also be a nice way to a nice forum to say, let's meet for an IEP to consider this additional information.
Mhm. Yeah, absolutely. Next thing, date of the most recent evaluation and the next reevaluation. So after the initial evaluation, the school must evaluate at least every 3 years. Again, as I mentioned, that can be more often if your student has needs that aren't being met. If you get new information, maybe they get a new diagnosis or you get an outside evaluation that disagrees with the school district's. Um, and this section of the IDEA lays out the procedures for conducting evaluations, um, providing notice, describing evaluations, which will usually happen at a domain meeting or a consent assessment planning meeting. That parental consent is required, and this is a very important thing to note, that you have to give your consent for each and every evaluation. So please do that if you want an evaluation, because that starts, once consent is received, the 60-day timeline for the school district to actually complete those evaluations. And as Elizabeth noted, it's 60 school days. So it can take quite a while to get the evaluations completed and reconvene. So you want to get the school started and get the clock started on that as soon as possible. And then another note about evaluations in this section is that the school should use a variety of assessment tools and strategies to assess in all areas of suspected disability. So they shouldn't limit it just to one area or say, well, this is our primary concern in schools, so we're only going to look at reading. No, they should assess in all areas of suspected disability. I think the regulations say that evaluation should be sufficiently comprehensive to identify all of the needs of the student. Okay. We had a question about eligibility category. The IDEA provides a definition of what a child with a disability means under the IDEA, and it provides 11 specific eligibility categories. They're listed here. I'm not going to run through all of them. A couple to note. Other health impairments, OHI, that's sort of a catch-all for things that aren't identified under one of these areas. ADHD is, I would say, most commonly eligible under OHI. And developmental delay is another catch-all. That's for students in Illinois. It's for students aged 3 through 9, and it's kind of a way for the school district to agree. Yes, we think that there's some delays that your child has, but they're young and we can't really identify what exactly it is, so we're allowed to just put them under developmental delay for now. And so they need to have one of these 11 disabilities, and they, because of their disability, need special education and related services. And I saw a comment in the Q&A about 504 plans versus IEPs. The main difference is that to get an IEP, you have to show that your child needs specialized instruction. This doesn't necessarily need to be a specific class or subject. It could be as simple as my student needs time in a resource room for executive functioning issues, work with a special education teacher on that. But you need to show that there's some need for specialized instruction. Otherwise, your student's needs may be able to be met under a 504 plan, which provides accommodations and modifications. There was a question on eligibility category. It really depends on the student, so I don't want to provide a broad answer. Oftentimes, it might not be worth fighting with the district over it, as long as they're identifying your students' needs and providing the services. But there are some specific areas where it is very important. For example, if a student is going to be placed in a private therapeutic day school, they actually have requirements about what types of students they are allowed to take. So eligibility becomes very important in that area. So I would say if you have a specific question about a school's, refusal to change a label or disagreement over what should be a primary or a secondary, you might want to follow up for some additional information about how important it is in your situation. And then this section also outlines the meeting participants, so who should be at a meeting. The first thing it lists is parents, very important. We're going to keep stressing this as a parent. You have a right to participate, and you really are critical to the IEP team to provide information, feedback, insight about your student. It should also include teachers, a representative from the local educational agency, which is just sort of the fancy word for district, clinicians, related service providers, and the student if appropriate, which often as a student gets older, it's helpful if they participate in their own meetings because they can provide insight as well.
I'm not going to touch too much on this because I see Will did it, but just as if you're looking for kind of a snapshot of what would be in that first, typically it's the first page of the IEP, kind of it's like the cover letter for lack of a better word, but it really does help give an idea of these really key dates, eligibility. So again, that first page is it's a lot of little boxes, but each one of those boxes contains very important information. So it's here as a snapshot when you want to look at it.
Yep. Okay, next on the IEP is usually, or I think pretty much always, procedural safeguards. Quick background on procedural safeguards. These are the legal protections that parents have in terms of participating in IEP meetings and disagreeing with the district when they do. Under IDEA, as a parent of a child with a disability, you have the right to examine all school records relating to your child. So if you have a disagreement with the school, one of the first things we usually recommend is go get their records from the school, see exactly what's going on. What's in the related service provider logs, what's in their IEP report cards. Are you even getting those consistently? So it's important to understand that you have a right to examine all records and request a copy of records from the school. You also have a right, and I touched on this just a second ago, but a right to participate in meetings. Meetings with respect to identification, evaluation, educational placement, and the provision of FAPE. So basically any IEP meeting, any meeting to determine eligibility for an IEP, any meeting to change the IEP, you have the right to participate. And there are a couple additional protections about how you are supposed to be allowed to participate that I'll talk about in a second. But the last thing kind of important to note in this section of the IDEA is that you have the right to obtain an independent educational evaluation of your child. This can be done privately at any time. You can go and get a private evaluation, pay for it out of pocket, use insurance, and the school district is required to at least consider the private evaluation. You also have the right to request an independent evaluation from the district at no cost to you, at the cost of the school district. I will note, though, if you request an independent evaluation from the district, if they don't want to give it to you, they are going to file for due process. They're actually legally obligated to file for due process. So if you are going to request an IEE, I would recommend talking to somebody about it first, maybe checking with an attorney, because otherwise you might end up in the middle of a due process hearing when you just thought you were getting a new evaluation. Two notes on Illinois laws that provide some additional protections for parents in participating in IEP meetings. So schools are required to provide written notice ahead of time. And in Illinois, what they call a reasonable amount of time before a meeting is at least 10 days ahead of the meeting. So you have to get a notice of conference explaining the purpose of the meeting, any data that's being collected for the meeting, at least 10 days in advance, unless you waive it. Oftentimes schools will ask a parent, oh, hey, can we have a meeting in 2 days? This issue popped up. You are completely within your rights to say, no, that's not enough time for me to prepare. Please send me a notice of conference for at least 10 days in the future, and I'm happy to meet then. You also, and this is a fairly recent law in Illinois, I think it's only 2 years old, and it's a really, really important one. You have the right to be provided a written copy of any draft IEP or evaluation results that are going to be discussed at a meeting at least 3 days before the meeting. And so I always recommend to parents, when you have a meeting scheduled, if new evaluations are being completed, whatever, send an email to the case manager, say, hey, we have this meeting, please send me a copy 3 days in advance. And if you haven't gotten them 3 days in advance, email them again on that day and say, I need these records because I need to review what's in the IEP so I can adequately participate in the meeting.
Hey, Will, can you real quickly just say 10 business, school, just remind us how are these days counted?
So, and that's a good thing to point out. Kind of frustratingly, it varies depending on which aspect of the law we're talking about. Some things are 10 school days. In terms of written notice, that's 10 calendar days. So they have to provide it 10 calendar days at a time. But there are other areas where we'll be talking about 10 days. And I always try to clarify if it's school days or business days. But that it gets a little tricky and it's really confusing. I don't know why they did that. I wish it was all just the same. So like we said, prior written notice needs to be provided. Written notice needs to be provided ahead of a meeting. It also needs to be provided whenever the district is proposing to initiate or change or refuse to initiate or change services in the IEP or to find your student eligible for an IEP. And this is really important because if the school district tries to change your student services, they need to give you 10 days notice. So they can't put those changes into effect for 10 days. I will note that the administrative code in Illinois is a little wishy-washy on this. I think it's 10 school days. That's what I would argue, but it's really still unclear. So if the school tries to change your student services, and we'll talk about this at the end, but you should request mediation or request a due process hearing within 10 days of that if you want to stop that change from going into effect. It's what we call stay put. It freezes the IEP and will keep it in place until the dispute is resolved. As you see right below that, one of your procedural safeguards is you must be provided the opportunity for mediation or to present a complaint if there's a disagreement, a due process complaint. And then just a note, generally parents must be provided a copy of the procedural safeguards every year. So you need to get it when the student's first evaluated and then at least once a year thereafter. I know it for parents who've had a student with an IEP for a while, it sort of becomes almost a joke with the school, like, oh, here's your copy of the procedural safeguards. But it's a really important thing because we want to make sure parents are informed of their rights. And if you're not given a copy, then you might not be adequately informed of your rights. And you might have an argument that the school district violated them.
And I think when you get that packet that's slid across the table, if it doesn't make perfect sense to you, have an administrator sit down and walk you through it, right? Underline so that because there is a ton of information, it is their obligation, the school's obligation to make sure that families are not just given the procedural notices, but that they understand them.
Okay. Yes. And I see. Yeah, I just saw the note about time. I will pick it up. I'm sorry. It's a lot. And I will, one other note on that, you do have a right to get the procedural safeguards and any other relevant documents in native language if you are not a native English language speaker. There was recently a great settlement that Equip for Equality had regarding, I think, Chicago Public Schools specifically providing translation services. So you might want to check with them about that. But important to know that if you aren't, and English is your primary language, you have a right to get it in your native language. Okay. Speeding up now. Next in the IEP is usually the present levels of performance. What does the law tell us about present levels of performance? The IEP must include a statement of the child's present levels of academic achievement and functional performance, including how the disability affects the child's involvement and progress in the general education curriculum. Okay, so that sounds good. We need a present level of performance. Elizabeth, can you tell us how that actually comes out in the IEP or why it's important?
And what I'm going to talk about is what it should look like, because I do see a variety of IEPs where this information is not there, but I strongly suggest you advocate that it be there. So I'm gonna, pardon me, but I'm just gonna hit on the bolded words here. The importance of not only deficits, but also strength. I know IEP is a deficit-based model and IDA is a deficit-based model. However, research talks about you use student strengths to address challenges. So really putting that front and center. And yes, there is this is a very small section of the IEP that talks about strengths. And usually I see, a couple 4 or 5 words. I really suggest you flesh that out. And this is also an opportunity to start to position your advocacy, what you want to get out of your advocacy, right? So for instance, if you want to emphasize that you think that the school should be improving a student's ability to have meaningful peer interactions, right? Meaningful pragmatic conversations here, then you might suggest put in this section, under what conditions and what settings is that student successfully able to have engaged conversations? And then you can use that as an opportunity to piggyback and say, hey, school, let's do this as well, because we see it's listed as a strength. We want to use strengths to address challenges. Just to touch on a couple questions here. When I talk about meaningful progress, so just to be clear too, because as you see, there's already so much we're trying to cover. We're only going to be talking about federal law and how it applies in Illinois, just for a couple people who are asking about other states. My apologies if that's where it's at. And then in terms of meaningful progress, right? There was a question about, I saw in the Q&A about administrators pushing back on the idea that families would question the data. Yes, you absolutely get to question the data. Let me give you a couple of ways to do this. So one, you can actually, could you go to the next slide? My segue. So again, as I talk about, I'll just go with this slide and then I'll address your question as I'm going through. So, no, I apologize. I'm going to talk about it now. So to get at that meaningful, what does that progress look like, right? You absolutely can push back on that. Not only can you request you get copies of progress on goals, you can also request what's called the raw data that informed the progress. I can't tell you how many times they said, this progress doesn't seem like it's lining up, or wow, every goal they made exactly the expected progress. That seems unusual. So I asked for the raw data. Lo and behold, it's not accurate. Then we start to have a conversation about how are you going to get valid data, why it's problematic to not have valid data, and what are next steps. In addition, as Will was talking about, an IEE is additional information that can come in that's like kind of a neutral party, hopefully, that can come in and share information to push back on or put a context to the data that the school is providing. You can also include and bring in, and we strongly encourage you to bring in private clinicians' findings and recommendations. So schools are obligated, I'm going to put this in quotes. Again, Will, if I'm doing any of this legal spouting off incorrectly, please just go, whoa, 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 stop what you're doing wrong, right? This is the benefit of a law firm that has, it's this team approach, right? Where they have to consider the outside report. So that's where, for instance, people like myself, we work very hard to best position, to position the school to best listen and incorporate those recommendations and to give it a reason why not, right? Talking about that prior written notice, here's a request to put in writing why you're saying no, right? Because sometimes schools don't like to do that. And then maybe they'll go, well, maybe we'll just give it to you anyways, right? So again, and I'm just hitting the tip of the iceberg. Yes, there's a lot of ways to push back on this idea of, no, you don't get to question the data. Absolutely, not only do you get to question the data, you get to fully understand what it means and where it's coming from. So again, we're talking about, just to skip down to the academics, when we look at progress on goals, I suggest that you ask that be included in the present levels, and if not, raise it, because what my training was when I used to craft IEPs back in the day, and boy, oh boy, is it a really crucial skill to, again, tracking that meaningful progress. If you have progress on the prior goals, and then baseline for the draft goals that are expected in that IEP. My training is that the present levels and the baseline and the goals should mirror each other, if not be identical. So the idea is that the present levels is giving a roadmap for how to, get a sense of where is a kid at and where are we going. Parent concerns, there is a section, again, they say at the beginning of the IEP, hey, do you have any parent concerns? Well, I suggest you really flesh that out. I suggest you, where you're comfortable, it's helpful to put these concerns in writing, because it gets, it's a paper trail. And a lot of times those IEP meetings they go really fast, and you might have this whole list of things that you wanted to bring up or concerns to address. And, you don't feel comfortable really fleshing the whole thing out while everybody's staring at you and going, let's go, let's go, let's go. We only have 45 minutes. You might feel more comfortable laying it all out. In fact, what I typically do is when I talk about that parent concerns, I also make it similar to the parent agenda, so that while we're going through the IEP, they're checking off. Okay, so we got a question about goal 1. Okay, goal 1, and they're going through it so that this is a solid way to make sure that the schools are attentive to your concerns and they're not getting lost. as well as a lovely paper trail. People like myself pick up on that and go, wait a second, the school, the family expressed this concern before, and you're continuing to not address it. And here it is, it's getting worse. Ding. Again, lots of things here, but I want to just talk about executive functioning. This is we used to call it just, put it in independent functioning back in the day. But now it's really been teased out, and it's, it's a component for every student, but some students don't have the developmental skills as they're going along. And we're talking about beyond just, materials organization. I've got color coded folders. We're talking about being able to plan your approach, being able to organize yourself to do that plan, being able to self-monitor. What are the expectations? Am I meeting them? What are the resources? I also often hear people come back and say, there's no curriculum. We don't have any research-based methodologies for that. My response to you is Rush. Rush Hospital has a rockin' curriculum. I see a number of schools in the Chicagoland area use it, and they give training. Rush, R-U-S-H, Rush. Ding.
Okay. Thank you, Beth. And talking about kind of getting into making expected progress or what your student should be able to achieve in a school year, let's talk about goals some more. So what does the IDEA say about goals? Well, the IEP must include a statement of measurable annual goals, including academic and functional goals designed to meet the child's needs that result from their disability, to enable them to be involved and make progress in a general education curriculum, and to meet each of the child's other educational needs that result from the child's disability. This is where we get into related services. If an aspect of your child's disability is impacting their ability to access education, progress in education, they need to meet those other educational needs. So that should be included in the goals as well. And then a description of how the child's progress towards meeting the annual goal will be measured, and when periodic reports on the progress the child is making toward meeting the annual goals will be provided, must also be included. I saw a question about, how do I know when my student's not making progress, or when can I go to the school and complain about not making expected progress? And, it depends on the student, to be honest, but the general answer is, well, the IEP should tell you, where they should be at various points of the year. Usually they're quarterly benchmarks that say, this is where we expect the student to be in 3 months from now, 6 months from now, 9 months from now, and then finally a year from now. So if they're not hitting those quarterly benchmarks, I would go to the school and raise concern that they're not making expected progress. The goals must also include a statement of the special education and related services, supplementary aids and services, all the stuff that needs to be included basically to explain how your child will advance towards attaining the annual goals. Often we see goals that say, a student who's reading at a second grade level will be able to read at grade level in a year when they're in 5th or 6th grade. And there's no explanation for what they're actually going to do to help that student make that type of progress, or what type of curriculum are they going to be providing. If a student has a specific learning disability, what peer-reviewed research, and apologies for my typo in here, but are they going to be using Wilson Reading, Orton Gillingham, things like that? The goal shouldn't be limited to, hey, this is the progress the student's going to make, but it should explain how they're going to make that progress. And then it should also include a projected date for the beginning of the services, modifications described, and the anticipated frequency, location, and duration of those services. This also, we'll touch on it later with the LRE grid, because a lot of times they'll say, you get 30 minutes per week of, social work or something like that. With that in mind, related services include developmental, corrective, or other supportive services, speech language pathology services, physical therapy, occupational therapy, things like that. These are noted in the IDEA, and I've provided the citation for where they provide the definition of the types of services. There's also a part of the federal regulations that talks on, what can be provided under related services.
Let's skip this one. Go to the next one. I think you covered this pretty well. So I want to touch on a couple questions that I saw in the chat box first. So grades, can have a lot of impact and sometimes have no impact. When I was a high school teacher, I won't say, well, I guess I kind of figured out the district here, but for students who had significant disabilities, grades were not relevant. It was more progress on goals. However, other students, many students, right, we're talking about low incidence populations, typically students who have very significant needs. And again, what they're working on is very divergent from the general education standards and curriculum. However, these days, it is really nice. Most districts have an online system where not only do they post the grades, it gives a breakdown of the grades. So people like myself go in and say, yeah, if they have extra credit, and we say, wow, they're getting, a 92%, my gosh. But then you look, you go, huh, they've gotten 30% of a whole bunch of extra credit points. They've gotten 100% on their homework. They're failing their tests. That tells me that they're probably struggling with either understanding the material or demonstrating their knowledge on tests. And that this 92%, for instance, is not really an indicator of a student's genuine understanding and ability to demonstrate their knowledge. Also, just to touch base on going back to what Will was saying about the curriculum. Yes, schools are absolutely obligated to use peer-reviewed, research-based methodologies. However, typically, I see that schools are loath, and boy, oh boy, my administrators trained me, don't put the curriculum in the IEP. I'm encouraging you not to spend a lot of time arguing about that, because I don't see that happening too often, because typically what the response is, you want to have the flexibility of changing curriculums. And I'm just suggesting there are other parts of the IEP where you say, okay, fine, not here, pivot and say, okay, what about in the accommodation section? What about in the supports for school personnel section? What about in the notes? So one of the kind of messages here is, your input is valid. Knowing where it fits into the IEP is tricky. And so in general, if you ever get that response, if it doesn't fit here, I suggest you say, okay, so where does it fit, right? I want to take a second and kind of paw through this, because again, my training, goals drive programming. And as Will was saying, this is also often a very meaningful place to go and look and see, what is progress looking like, right? Is it the same? And so, for instance, when we have a case, I will chart goals and we will compare over time and say, whoa, look, it's the same goal, or they made huge improvements, or they're not. It's a consistent pattern of they're not meeting expectations. There's a consistent pattern of the school doesn't include measurable baseline data, right? It's a really nice way to kind of step back and see. So again, I can't emphasize enough goals drive programming. So I'm just going to take a second to kind of flesh this out. Baseline. Typically, like I said, it mirrors the present levels, the beginning, or should mirror the present levels, the beginning of the IEP, usually early in the IEP. That baseline should be not only measurable, but directly related to the skills that are being targeted in the goals. Many times I will see, for instance, a standard score, right? They score, the standard score of 76 on the Castle idioms test, right? And sure, right, maybe the goal targets using abstract language and idioms, but they're measuring it based off of something that's totally unrelated to the Castle. I apologize, that is a speech and language evaluation. It's formal. You can only administer it, I think, every 6 months or once a year. So that would not be a good tool for progress monitoring. And it also does not give us an understanding of what is a student currently able to do, so that we are able to calibrate. We have a fighting chance of calibrating a goal that is both, sufficiently challenging and, as Will was saying too, not unreasonable in terms of it is a reasonable goal to make progress. Behavior, condition, criteria, context. So when I analyze goals, this is what I'm looking for, and a good goal should have all of these components. And again, it's very meaningful in terms of helping the school to understand and to be on the same page about what is it that we're monitoring, and that it's a meaningful goal. And the language that I often use if I'm trying to be a little bit more friendly at the meetings is, hey, we need to document this. Maybe I'm not necessarily disputing that you're going to do these things as you designed or as you're envisioning them, but the IEP needs to be written in a manner that if the family were to move, the next team could pick it up and it's very, very clear what to do. So I find that that's kind of a friendly way. And then what are they going to say? No, you're never going to move, right? That usually kind of things move forward with that. Behavior, specific skills. And I put that S there. Typically, we want to be very, very careful about what is the skill or skills. Be very, very careful so that the measurable components are, the criteria and how we're evaluating is very clearly attached to the behavior. The word measurable, right? It needs to be something that you, one more time, can measure. So when I see the student will practice, I have no idea what that would look like, what that would sound like, right? Again, no, it should be that the test should be, I should walk in the room, see the behavior, know, oh, that's the goal on this behavior. Condition. What are the supports that the student needs, will be getting while we are assessing their progress on the goal? So for instance, checklists, assistive technology, adult prompting. I'm pausing at that one because a lot of times too, I see adult prompting, and I'm suggesting too, for students, particularly students who have more involved disabilities, the level and intensity of prompting is how we mark progress. So you want to be clear. So hand over hand, hand over hand prompt is very different than a gesture of pointing to the notes, right? So you want to be clear, what are those prompts that we're talking about? Criteria, how is it measured? And again, that how it's measured should be really related to the meaningful aspects of it and the elements of the behavior in the goal. So for instance, reading fluency. Well, that's great. That's how fast can you read in a certain time? That's what the goal should be measuring, right? So again, you really want these things to line up. And as you can see, there's ample room to start to push back or help the team to make meaningful programming that's shared. And well, hello, Matt. Meaningful programming. I got called nervous there for a second. Meaningful programming that is, again, it's shared and understood by everyone. Context, where will the skills be measured? So I know, so we have some students, or pardon me, oh man, you got me all nervous here. Families that have students with autism on our call here. So oftentimes a student with autism can perform the skill fine, maybe like the social work setting, one-on-one, but then struggles to generalize it in other contexts. So really being clear about where are we measuring it is very important, because I know I have a number of students that I work with that, quiet one-on-one setting, oh, they were killing it. They were able to really demonstrate on-task behavior and really, use their strategies. But then same student in the general education class and with 30 students and a whole lot more hubbub, their skills are very different. So you want to be very clear about in what context those skills are being measured. Ding.
Okay, next we're going to talk about accommodations and modifications. As I mentioned earlier when we were looking at the text of the IDEA, the IEP should include any necessary accommodations and modifications that allow a student with a disability to access their education in the least restrictive environment. And generally, an IEP team should not remove a student from general education if they can make appropriate progress with accommodations and modifications in the gen ed environment. A note on 504 plans versus IEPs. I've seen questions about 504 plans. Generally, a 504 plan is used when a student needs accommodations and modifications as a result of their disability to access general education curriculum. An IEP is provided when a student requires specialized instruction. So an IEP can include all of those accommodations and modifications, but it's for a student who also requires some form of specialized instruction. And as I mentioned earlier, that doesn't need to be for a specific class or curriculum. It could be time in a resource room to work on executive functioning, organization, catch up on work, just have time to check in with a special ed teacher to make sure they're on track. But there needs to be some form of specialized instruction to get an IEP. Otherwise, accommodations and modifications can be provided through a 504.
With our advocacy, we often talk about short and long-term goals, right? So when we're talking, what do we want to put in place right now? And what are we hoping to attain down the road? So accommodations is a nice place to look at that, because that's often a space where we're looking at short and long-term goals. Short-term goal might be that we're providing an accommodation that will, again, support the input or the output for a student. It's not changing or altering the expectations, so that the oomph or the content is still the same, but we're just accommodating the input or the output. So short term, we might say, hey, we will give an accommodation that staff will break down the task for a student. So for instance, when they have to write a paper, what are the little steps and what are the mini due dates for when they should do that? However, you don't want a student to be 42 in a job and going, I'm so sorry, I don't know how to break things down. So in addition, while those accommodations are going on, you want to also have a goal and instruction that talks to teaches how to break things down, right? How to backwards plan, consider all the components, how much time do you have, what are your resources to make that plan? So short-term and long-term goals can also be a really effective way to organize your efforts and sequence your next steps and your priorities. Modifications, I'm just gonna, some students absolutely, they need them because that's where they're at. I just wanna put a caveat out there that it is a deviation from Common Core standards, general education expectations. So it should not be taken lightly, and it should be done only after, again, as we're talking about, all other supports, accommodations, supports and services can be put in place before we're looking at reducing the content that we're expecting a student to learn. Ding.
Okay, a quick note on assessment accommodations. So the IEP also needs to include a statement of any individual appropriate accommodations that are necessary to measure the academic achievement and functional performance of the child on state and district-wide assessments. If the IEP team determines that a child will take alternative assessments on a particular state or district-wide assessment, it should explain why the child cannot participate in the regular assessment and the particular alternate assessment that is being selected as appropriate for the child. It's important to have appropriate accommodations on these assessments, but I think part of the reason why we include it here is because of sort of the longer term implications of what having these accommodations are, which Beth is going to talk about.
Yeah, and I just to touch on real quickly that the assessment accommodations often are applicable when we're talking about SAT preparation or taking the SAT. If that continues to be, that might be a thing of the past, but standardized tests are still going to be a component. The College Board is who manages the SAT. They get to determine if a student gets an accommodation. And they are often looking at not only is the accommodation, for instance, of extra time a part of a student's plan, but are they using it? If they're not using it for assessments, the College Board would say, what, now all of a sudden you need it? And they'll be dubious. And often I see they do not, even if it's in the IEP, even if it's been in the IEP for years. Sometimes I see the College Board will deny the request for extended time, which can make a huge difference for students.
Okay, moving on to special factors. In the IDEA, there's consideration of a variety of special factors. These are things that might be in a particular student's IEP based on their disability and their needs, but is not necessarily included in all students' IEPs. A very common one is behavior. If a child's behavior impedes their learning or the learning of others, the IDEA says that the team must consider the use of positive behavioral interventions and supports and other strategies to address that behavior. The federal regulations take this a step farther, and they say that districts are mandated to complete functional behavioral assessments and behavior intervention plans to provide appropriate supports. This is really important because a lot of times students who are having behavioral issues, especially if they're in the gen ed or inclusion environment, one of the first things the IEP team seems to try to do is move them out, right? Put them in special ed or maybe move them even to a separate day placement. And a good behavior intervention plan and a good FBA and understanding of why we're seeing these behaviors and how to appropriately intervene can be really successful in helping students with behavior issues succeed in less restrictive environments. So, this is important, right? To know that your student has, and one that, if there are behavior issues, the first thing is request an FBA. If the student already has an FBA, look at the BIP and see if changes need to be made. What is or isn't working? And does a new FBA need to be completed to look at why we're still seeing behaviors even with the BIP? Another one is communication. I saw a question about least restrictive environment in terms of students who are deaf, hard of hearing, blind, deaf, blind students. And the IDEA says that the team needs to consider the communication needs of the child, including opportunities for direct communications with peers and professional personnel and direct instruction in the child's language and communication mode. This can be relevant if an IEP team is just saying LRE, LRE, you say, well, you also need to consider their communication needs. And if they can't get their communication needs met related to their disability in the current setting, the team should consider a change in placement to allow them to have access to those opportunities for direct communication. Assistive technology is a term that probably many of you have heard. The IDEA says assistive technology applies to devices and services. I have the federal regulations definition of what a device is and what a service is. It's very broad. Any item, piece of equipment, or product system that is used to increase, maintain, or improve the functional capabilities of a child with a disability. And then assistive technology services should assist with the selection, acquisition, or use of an AT device, such as an evaluation, the school purchasing or providing the device, customizing the device, coordinating use in therapies, and training for the child, family, and staff. AT is a very important area of special ed law and one that often gets overlooked or misunderstood by IEP teams. Want to highlight it here and make sure parents understand that you have the right to request this assistive technology evaluation. If the AT isn't working for your student, maybe a reconsideration for what would work better. And it can be really important to allow students with disabilities to access their education in all environments, but particularly in less restrictive environments. Two other areas that I'll note is extended school year services, which is special ed summer school. It's for students who either regress over the summer or aren't able to make appropriate progress during the school year. I've included the citation for the federal regulations where ESY is discussed, and then transportation services. So I saw someone, was here to discuss transportation services. Transportation is included as a related service under the IDEA. So if your student needs transportation services in order to access their education, in order to get to school, then they're entitled to get transportation from the district at no cost.
So to talk about the application of assistive technology, so just to kind of piggyback off of what Will was saying, we're talking about technology. This means high tech, like a device, like a communication device or a computer, or low tech, like here's a break card, right? So you really want to be looking at all tools that will help level the playing field, right? And this should start with an evaluation where we're looking at a student's unique needs and their profile. I often see that instead, especially with this day of, after COVID and one-to-one technology, it's like, oh, this is what we have on our shelf. Well, let's just have the student use it. Yes, it is typically preferable to use what is commonly done within the context. I'll talk about that when I talk about social barriers in a second here. But more importantly, kind of like the idea of FAPE, it needs to be appropriate to that kid. So what my training is, and I've talked with a number of AT people over the years and try to keep up with the research, and this seems to be continuing to be relevant. So before you even start to identify tools, you figure out a feature match. Pardon me. First, you look at referral questions. What are we hoping to accomplish through the assistive technology that will help the students use broader vocabulary and more easily and more quickly get their thoughts down on paper, for instance, right? What are some ways to do that? And then we look at motor, what are their motor skills and ability to do that, cognitive skills, and social. So in what context will they do it? So that's where I was speaking before about, yeah, a lot of times it is helpful that if the whole class is using a Chromebook and the teacher is instructing a Chromebook, yeah, you want to consider a Chromebook first before maybe an iPad, right? So that we're not creating additional schemas and barriers for a student. But more importantly, though, I contend So does IDEA. It's got to be appropriate to the student. And it should also include trialing the tools in settings, right? So we really want to see if it'll work, for instance, in the general education classroom with 30 students, right? Maybe that speech to text, that's not a good tool for that setting. So you want to, again, really match it to the setting. You can also, and just to leap ahead just quickly here, for can be a related service as well, where you can have assistive technology people be a part of the IEP, where they're saying that we're going to give training, we're going to check in on things. So I'm just, the assistive technology, there's a bunch of support. And if the school is saying, we don't necessarily have all these resources, Illinois does. So here's a resource that you can refer them to. Behavior intervention plans. That's a whole seminar, it's a whole presentation unto itself. We actually have a number of PowerPoints on our website too. I'll refer you to look, just to give it up, just a couple quick points on that. Again, it starts with what are we looking for, right? The operational definition of the behavior. I see that being lackluster at best in a number of behavior intervention plans. Again, can I walk in and see it? Or is it dependent on, did that teacher have their cup of coffee and are they in a good mood? It shouldn't be that, right? It should be so clearly defined. Anybody can walk in and say, oh, there they are. They're on the floor, right? They're kicking. It's very clear, right? And there are staff. So like all things, FBAs can be well done or very poorly done. And sometimes I see them used to kind of reinforce the idea that the student should just comply. Oh, no. It's very, very far removed. Actually, a behavior intervention plan should really be a plan for the adults on what they need to be doing to support a kid to use more appropriate replacing behavior. The thrust of behavior intervention plan is very beautiful, right? The idea behind it is that we need to honor the function of students' behaviors, right? So if you're screaming and running out of the room, why are you doing that, right? We need to figure out why are you screaming and running out of the room, or just not addressing a teacher, right? Or not completing work. There's a lot of behaviors we can include in the behavior intervention plan, and they're not all externalizing aggressive behaviors or challenging behaviors that you could see on the face. So again, one more time, honoring the function. Why are you doing this? And then giving truly meaningful replacement behaviors that actually address that function, right? So if the function of a student's behavior is they're trying to avoid the task, well, it's not really meaningful to just expect the student to just do it. That would be great if they just complied, then we wouldn't be talking about a behavior plan. Instead, what do they need to honor the function of, maybe they're saying, I don't want to do this now. So maybe you give them a card that says, can I have a break, right? So that, and then we can talk about how to get back to the work, honor the function of the behavior with more appropriate replacement behaviors. It can be a beautiful thing and a very meaty place to advocate for effective strategies and what the staff should be proactively and effectively doing. Thank you. Ding.
Excellent leeway, Elizabeth, because the next thing we're going to talk about is supports for school personnel. Looking back at the text from IDEA about what needs to be in the IEP, this time in looking at it, I've highlighted that it should include a statement of supports for school personnel that will be provided. And this is really important, both for making sure that the student is able to make appropriate progress towards attaining their annual goals, right? How is that student going to make that progress in reading? Or how are they going to improve their executive functioning? What training or what qualified staff is going to be providing these services? And then also to be involved in and make progress in the gen ed curriculum. So, I mean, behavior intervention plan is a perfect example of, what training does the student's one-to-one aide need, or what training does the classroom teacher need to be able to take that behavior intervention plan and appropriately implement it to make sure that the student is getting that redirection or getting the support that is outlined in the IEP. I think a common complaint that we hear is that you go to the meeting, you have a discussion, and the team writes out all this stuff in the IEP, and it sounds great. And then it seems like it doesn't happen, right? And that can be for a variety of reasons, but I think one area where sort of a disconnect can occur is, well, what's provided for in the IEP And how has school staff actually been trained in order to implement those services, on a day-to-day basis?
It can be broad, and as well as saying, but so I'm just gonna, but it should include very specific details. Who's doing it? When is it going to occur? What does that look like? So, and typically in an IEP too, if you see the little language right underneath supports for school personnel, it lays this all out. So you can just point to the team and say, please answer those questions. You don't have to do any of the work. Just point to the document. And then I just want to take a moment here. You see there's some examples, you can say, yes, hey, we should get training for Wilson reading. So for instance, that's a way to kind of integrate the research-based methodology that a student should be receiving. Again, the students that I often work with had aides that work with them. And typically they're the least trained person in the room doing, the most heavy lifting, the boots on the ground sort of work. And oftentimes they're not even privy to the information from the IEP. So what I did, not based on research-based methodology, is I worked with the teachers to generate what's called written instructional plans. So the aid, and I wrote them in a way that even if a sub were to come in, and granted, this is also a place that if a student has particular training, like they need to get ABA or they have medical needs, this is a place we can also make those notes as well. And so sometimes a sub would not be appropriate for just any student to come in and to be their aide. So, but written so clearly so that the aide is very clear at this stage. What is my role? What's the student's role, right? I need to point to their checklist and they follow their checklist. If they don't follow their checklist, right? So written so that, again, if I were standing in the room, I would see these step-by-step directions. I don't see this happen very often. Boggles my mind as someone that, when you have to supervise a number of aides who are across a variety of classes, how do you possibly know that they're doing the program with fidelity if they don't have a written instructions? So I would really push back. And again, as we were talking about what Will was saying, that sometimes you've got this beautiful IEP, but it's not implemented. This is one way to kind of approach it, right? And there's one way of assessing as well. How closely do they know what students' needs are? And if someone goes in and observes, that's also a way of checking, okay, here's the plan. I'm not seeing that, right? So again, to gauge the implementation, to put some accountability in there, as well as really give the school a fighting chance to help that student in the meaningful way, in a consistent way, that's bringing to bear all the information we know from clinicians, from the IEP, again, in that moment, boots on the ground when the aide's with the student. Ding.
Okay, we have about 10 minutes left and a couple important sections to get to, so try to be quick. Transition services. So the IDEA, and I want to put a big caveat on this because of the line at the very bottom of the slide, but the IDEA says, beginning not later than the first IEP to be in effect when the child is 16 and updated annually thereafter, the team has to talk about appropriate, measurable post-secondary goals based upon age-appropriate transition assessments related to training, education, employment, and where appropriate, independent living skills. And I mean, this in some ways is sort of the culmination of the IEP, right? The purpose of a public education is to prepare students to get ready to live in the real world as adults. And a great thing that transition services and IEPs do is sort of drill down on what are some of those skills that maybe students in general education just get naturally through gen ed curriculum that aren't as identified in the gen ed curriculum. So how are they getting ready for employment? How are they getting those independent living skills so that they can live on their own? And that's really what we want to be looking at when we're talking about transition services. Transition services should identify what's needed to assist the child in reaching those goals. And a note, like I said, in Illinois, it's actually earlier, we talked about how state law can give your student more rights or protections than the federal law. So the federal law is 16, but in Illinois, it's the first IEP that will be in effect when the student turns 14 and a half. So at that point, we want to start talking about what's the plan for after high school and how are we going to get them ready for that. Another note, and this will be important for the next slide, is that at least 1 year before the child reaches the age of majority, so in Illinois, before the child turns 18, there should be a statement about informing the child of what their rights are that will transfer to them when they turn 18. And this is really important because students in Illinois can continue to receive services through the age of 21, so until the day before their 22nd birthday. But once your child turns 18, they're in charge of their education. So you want to make sure that you're communicating with your student and that you're on the same page about what the plan is for, after 12th grade. Are they ready to go to some college or university? Are they going to go and start working a job? Or do you want them to stay in the public school system and continue receiving services? Because if the IEP team agrees, your child can stay in school beyond 12th grade and continue to receive services through the public school. They don't need to be in school all day. It can be part of a part day or a couple days a week program where they continue to receive some services while also attending college courses at a community college or working at a job. But they are entitled to continue receiving those services until the day before their 22nd birthday. Importantly, they're entitled to that if the team agrees and they don't graduate. This is a really important thing to note because sometimes, especially when I was at Equip for Equality, we get calls from people that said, my kid is 19, they graduated high school last year. We just realized they still need all of these supports and services that were in their IEP. And it's really difficult to get the student back into the school system after they've graduated. So you want to make sure you're on the same page with your student and with their IEP team. And if necessary, you may want to defer graduation so they can remain enrolled in a transition program after, they can still walk across the stage and get a certificate of completion, things like that. But you want to defer, the diploma and the formal graduation until they're ready to move out of the public school system or until that 22nd birthday.
Here's some information, but I'm also going to talk about, preparing for it. So we're talking about at 14 and a half, that's when the Illinois starts to chime in and say, now we need to really prepare you for your adult living. A quick FYI, this comes up a lot in meetings and with families or clients. At 14 and a half, at least in Illinois, students are invited to their IEP. This does not mean they need to attend. The family, the guardian gets to decide that, because sometimes it's difficult to have, frank conversations when we're worried about, and part of the conversation is the student's self-confidence, and they're sitting right there, right? It can be a difficult, awkward, or impossible conversation to have. So, and participation does not need to be all or nothing. A student can join at the beginning, share their 2 cents. I'm a big fan of what's working, what's not working, what changes might like. That can also be put in writing and shared by someone else. And sometimes students are pulled in at the end. I find logistically that's a little tricky, can be a little anxiety provoking for some students, but some teams make it work. So again, just want to be clear that just because a student is invited doesn't mean they need to attend. But we do want to think about meaningful participation and how to, keep them in, have their say, as I'm going to talk about supports here. But the discretion is for the parent and the guardian. Also, when we're talking again, 14 and a half, I contend that transition planning should start way earlier, right? So at every stage, basically, and I think about my kindergarten students, when I'm talking about what's meaningful for a 5-year-old, I'm also thinking, again, short-term, long-term, are these meaningful skills that they're going to need when they're 20, 25 and beyond? So that we're really lining up the programming and actually, pardon me, I should go this way, in a backwards planning sort of fashion, right? What are priorities, and continue to talk, right? Like, we really want them to be able to live on their own. Okay, so self-care, being able to, brush your teeth, being able to do those things independently, that's important, right? So that, again, so the eye of individualization, right, of an IEP, very based on students, individual goals. But again, I'm as much as the immediate can feel so overwhelming and there's a lot to be doing, I am strongly encouraging to continue to look past the forest, look past the trees to the forest, big picture here, and get a sense of what are we going towards. So we're not just kind of, zigzagging forth, maybe not going towards a meaningful play, not preparing a student for meaningful adulthood, right? We really want to be thinking about what are those components for this student, continuing to be thinking about that, continuing to revise that, and then planning accordingly. So again, this idea of meaningful vocational and transition evaluations and programming. Again, I see quite a bit of variety. I often see a pretty cookie cutter, we do a survey, right? Well, that may not be meaningful for some students because maybe a piece of paper is not resonating with them and they need to go see the job. They need to be there. Maybe, again, programming of, continuing to wash dishes in the school's cafeteria. Well, maybe we need to look at a variety of programs and see what's out there. So again, the student we're looking at meaningful opportunities. I've seen, I think of a couple of transition plans where I think the team was just checking off the boxes. I don't think they were really considering the student and what we're preparing them for. What comes to my mind is a young man with terrible fright of being around anyone or speaking. He liked movies, so he said, I'll be an actor. We're all like, really? So what would be the instruction and the skills to get there? Clearly, this young man did not have any sense of what are we looking at? We're looking at careers, right? What does it mean to have a vocation? And so it's uber important to have not just that we're checking off the boxes saying we've done transition planning, but that it's really applicable to a student, because as Will's saying, after 18, after they graduate, or 22, you get adult services, but that's a moving target. So really, really important. Backwards planning, meaningful transition planning.
Okay, we're gonna run a little long. We're pushing up on 1:30, but we're getting close, folks, I promise. So one of the last things we're gonna talk about is the educational placement and services. Remember, we talked about it at the beginning, right? FAPE in the LRE. Your student has a right to be educated in the least restrictive environment. And so, looking back at what the IEP needs to include, a statement of what services they're going to get, what special education, related services, supplementary aids and services that will be provided so that they can be involved in and make progress in the general education curriculum, and to participate in extracurricular and other non-academic activities. We want to make sure that we're determining placement and through the lens of least restrictive environment, and to the extent that a child with this disability will not participate with non-disabled children in the regular class, and needs to explain what that extent is and why. Oftentimes in an IEP, you'll see them walk through sort of the continuum of the percentage of time a student's going to be pulled out and check off whether or not that's appropriate for a student. So we want to make sure we're going through the continuum from a view of, let's start with the least restrictive environment and move towards more restrictive and see, kind of what is the student's LRE.
So there's a point in there that talks about push-in services versus pull-out minutes. The IEP should say where those services are happening. As well as I just want to emphasize that while we're talking about a student's programming, the appropriateness of the program comes first and foremost. And then we look at in what environment. So really that is essential. So again, I heard this, I saw a couple questions about, what if a student's, we think they need more, or they need to be in a less restrictive environment. Again, emphasize what is the appropriateness of the instruction and the programming, right? Do they need to be around general education peers to have neurotypical models for how to, comport themselves in a school-ready way, right? Or because are they maybe copying the behaviors of students who are in more restrictive environments? And that, again, emphasis on appropriate. So what I'm going to say for this part real quickly is that, again, there are lots of times where I hear people say, well, I asked the question, I was rebuffed by just saying that doesn't go in this section, right? So I suggest, again, one more time, you say, where should it go? And then also as a really nice, you can Some teams may be more willing to put things in the conference notes than other sections of the IEP. And the conference notes are just as legally binding as every other part of the IEP. So if they're pushing back, say, write in the notes, please.
Yeah, and I saw earlier a question about a common occurrence at meetings might be the team spends, the majority of the time talking about the student's strengths and weaknesses or something, and then they skip over a bunch of stuff, right? Um, One thing I would recommend is if you feel like the team is rushing or you don't have time to discuss everything you want to talk about, you should say, hey, if we don't have time to talk about this part of the IEP, I would like to continue the meeting and reconvene at a later date when we do have more time to talk about this. And because I would be really wary of schools saying that they're going to do something without putting it in the IEP. If you can't continue the meeting or you think something should be in there, but they don't put it in there, we'd recommend you send a letter of dissent, which is just a letter saying, hey, I disagreed with this, what happened at the meeting or what was written in the IEP. This is my view or my understanding, and I would like this letter attached to the IEP to provide my perspective. IEP implementation, if your student doesn't get the services in their IEP, they may be entitled to what's called compensatory education. A note on getting the services in their IEP, because I saw a question about, schools that don't have appropriate staffing. There's a law in Illinois that says schools must provide written notice if the services in the IEP aren't implemented within 10 school days of when the IEP goes into effect. Apologies for the typo. This isn't like an Apple version of the iPhone or IEP. Just missed the shift button on that, I guess. But yeah, so the school needs to let you know. They need to provide written notice that says, hey, we don't have an aide. We know we added an aide to your child's IEP, but we're trying to hire one, but we don't have one yet. Or we maybe have an aide, but they're not appropriately trained in the support or the training that your student is supposed to have. And as a result, they're not getting the services in their IEP. And if that's the case, then your student may be entitled to compensatory education, which generally means additional services to put the student in the place they would be in had they received appropriate support. So if your student's not getting what's in their IEP, the school might have to give them extra services later to make up for it. Students can also get comp ed in situations where the IEP just doesn't provide FAPE. So if the team won't agree to put something in the IEP that your student needs, or they overlook an area of need and it's discovered later, your child might be able to get additional services to make up for that previous denial. The last thing we're just going to quickly touch on is IEP disputes, right? So what if you disagree with the IEP team or they aren't following the IEP? Elizabeth just gave you tons of good information about what should be in there, what you should be looking for, what you should be asking for, and what if the team just won't do it? Well, there are a number of advocacy strategies that range from things that you as a parent can do on your own to things that you might want to hire an advocate or attorney for. The most basic one, right, is request an IEP meeting. So if you have concerns about what's going on in school, you're not sure what services your student is getting, or there's just some disconnect between what's in the IEP and what you're seeing from afar, request a meeting, talk to the team, figure out what's going on. You can also request that the school conduct updated evaluations. If the evaluations are outdated or something has changed, your child has gotten a new diagnosis that isn't considered in their IEP. Or you can get support from outside experts. So if the school is saying, well, this is what our psychologist says, or this is what our speech pathologist says, as a parent, trust me, I fully believe that parents know their children best, and that you probably know more than a lot of the so-called experts who are on that IEP team, because you are an expert in your own right. But unfortunately, a lot of times the IEP team in the school district is going to side with their clinician. And so even if, it seems obvious to you that what they're doing is wrong or your student needs more services, sometimes it can be really helpful to get outside support from a private speech pathologist or a private social worker or somebody to sort of back up what you already know that your student needs. And if that still doesn't work, there are formal dispute resolution options. As I mentioned earlier, the procedural safeguards provide that you need to have the opportunity for mediation or to file a complaint. There are a few different options. You can file a state complaint with ISB. you can request mediation with the school district, which is a meeting to discuss, kind of what's going wrong and how can you fix it. But an important note on mediation is that it's voluntary, so the school district doesn't need to agree to it. Or you can request a due process hearing, which is the administrative proceeding that's designed for when parents and school districts disagree. I will caution you that due process hearings are really complicated. It's like a mini trial. There's a hearing officer appointed to listen to testimony, review evidence, and make a decision basically about who's right and who's wrong. So if you're thinking about requesting a due process hearing, I'd recommend contacting an attorney to get some more information on how those proceedings work, what your rights are, and what you need to be prepared to do with or without representation. And then finally, I touched on this earlier, but an important note in regards to IEP disputes, if you disagree with changes the school has made to your student's IEP, and specifically if they've moved your child to a different placement or removed or reduced services, things like that, you have 10 days to invoke stay put by requesting mediation or due process if you want to stop those changes from going into effect.
You will. Could you clarify what kind of days those are, please?
Yeah, so I just do 10 calendar days for this one. I would argue that if you look at the administrative code and Illinois statutes, that maybe you could argue it's 10 school days, but you don't want to mess around. So this one, just do 10 calendar days from the IEP meeting. And one final thing on this, which I don't think I mentioned at the top, and this is, I promise, our last slide, so we'll let you go. But a lot of times parents ask us about signing the cover of the IEP. So they'll say, oh, I disagreed with the IEP, but I didn't sign it. Or I told them that I disagreed with the change they made. That's not good enough. Signing the IEP, there's a signature at the front where you sign in as a participant. And then there's a request to waive that 10-day period. So when we talked about they have to give you 10-day notice of when they're going to implement changes in the IEP, you can waive that. So if they say, we're going to give your student an aid, do you want us to wait 10 days or do you want us to start tomorrow? You can waive the 10-day period and say, no, I like this new IEP. I want to start now. But if you disagree, you definitely don't want to waive that 10-day period. And you want to make sure within 10 days to request mediation or file a request for a due process hearing. So, oh, sorry, go ahead.
Yeah, so there was a couple questions that were related to not Illinois regulations. One resource I know of, and it's great to have Matt here too, is if there are other resources, sir, you have COPA, C-O-P-A-A. They are a national organization, but actually Matt helped found, and they have a number of resources for advocates, attorneys, as well as just a number of resources that as I recall, are also are state-based as well. Am I getting that right, Matt?
Yeah, that's certainly true, though the bulk of all regulations are federal. So it's good to check and double check because there are individual state variations, but most of what Will and Beth have been talking about are generic across the states.
Yeah, I see a question about in California, the school cannot change a child's placement without consent. I don't know about California specific law. I can tell you that's absolutely not the case in Illinois. They don't need the parents' consent to change placement. It's an IEP team decision. So even if you flat out say, no, I disagree, if the rest of the team agrees, they can go ahead and change the student's placement unless you invoke stay put. Let's see, any other questions? I see a couple other questions. I don't have time to get to them. Generally, civil damages, no, not available in connection with IEP violations. You can get compensatory education to make up for it, but there isn't like a, personal injury damages or, punitive damages or anything like that in order to make up for the denial.
And as we noted at the top, there's so much to cover. We're just bird's eye view here. We're going to do a deeper dive in the second round. We're taking these same concepts, but again, just going deeper into it. And I took note of a lot of comments, so I'll also be working to flag that and incorporate, because again, we weren't able to, I apologize if there were questions that were asked that we didn't get to. I'm trying to track that to make sure that we address it the next time, this round 2.
Absolutely, yeah. And so hopefully people learn stuff. Feel free to follow up with the firm, with me, with Elizabeth. Our general intake number is included here. If you have specific questions about the content that was in the presentation, we will make the slides available so you can look through them, because I know there was a lot of information. But if you have questions or concerns that we didn't get to, feel free to follow up with us. Otherwise, we'd love to have you join us for part 2 of this presentation, which is going to take a deeper dive into some of these advanced advocacy and legal strategies for when you disagree with the school, right? So we've talked about what should be in the IEP or what your child is entitled to in their IEP, but what can you do to make sure they're getting it? Or what can you do when you disagree with the school? That will be the focus of part 2.
Thank you so much for joining us. Really appreciate it. We have a lovely
Thanks,
day.
everyone.